Here's Chapter 13, the proceedings before the trial. So when you get picked up for a crime, what happens before any trial begins? One of the first things you're going to do is you're going to go to the police station somewhere to get booked, provide all the personal information, maybe get fingerprinted. If it depends on the crime, maybe a DNA sample. You might have to provide some blood, a writing sample, get your photograph taken. And then initially, when you can, probably the next day, you will be seen in front of a judge. If it's the weekend, you have to wait till Monday. They tell you about the charges, your rights, and sets bail if possible, if they need to. Misdemeanor appearance, you just say, I'm guilty or not guilty. If it's a serious felony, more serious, you don't enter that plea. Things about bail and pretrial. The purpose of bail is to make sure that you come back to court. So you put up some money, they'll give it back to you if you show up to court. If you don't, they keep your money. But it does allow you to get out of jail before your trial. If the defendant doesn't have money, there's a bail bondsman, someone you can pay, and they're going to charge you interest and make money. Sometimes they don't have bail, and they just say personal reckonance, meaning that's your promise, I will come back, you can trust me. Maybe it's a low-risk criminal. Sometimes they have a third party to watch you, make sure you're working at a certain place, reporting to people. Again, what happens if the defendant commits crimes while released on bail? You will go back to jail. The problem, many defendants commit crimes while they're out on bail. They are habitual criminals, so they keep committing crimes. Sometimes you have preventative detention, so in bail, there will be none for you. You're accused, maybe be held without, has to be a good reason. Maybe you committed a very serious crime of some sort. Some of the information that you're going to provide, nature, circumstances of the crime, what kind of crime it was. In this beginning part, only uses the prosecution's, the government's investigative work and evidence. They just hear what happened initially. In a preliminary hearing, it's used in the felony cases. Is there enough evidence here for the defendant to actually go to trial? This is a little bit less than a grand jury, but both sides will hear some evidence back and forth. In a grand jury, for the very serious felonies, they go to a group of 16 to 23 people who meet like once a week, and they decide if they want to indict this person. Was there enough evidence to formally charge that person? It's only the prosecution's side and evidence. In an arraignment, so the arraignment and the pleas used in felony cases, if you plead guilty, then they set your date. Like, I did it. Here's your court date, then to tell me how many years in prison, fines, things. If you say not guilty, then you set your trial date, and they decide if it's a jury trial or a bench trial with just the judge. You can also plead no contest, meaning like, yeah, you are guilty, but you just don't feel like it's right, but you're just going to say I'm guilty. Ways to kind of keep things going, exclusionary rule, as well as motions. So motion for discovery of evidence, request the defendant to examine certain evidence of the prosecution before trials. We want to see some of your different evidence. Continuance, you just need more time to prepare for the case. Change of venue. Maybe that location is not good. Maybe you want to avoid the community outrage, hostility, so you want to have the trial somewhere else. Suppress evidence, request that certain evidence not be allowed. It was illegally obtained. It doesn't have any. It doesn't pertain to the trial at all. So again, what is the exclusionary rule? Exclusionary rule means that any evidence that was illegally obtained has to be thrown out. So, for example, Matt versus Ohio, the police went into someone's house without a search warrant. They were looking for explosive weapons. And when they were searching their house, they found some illegal pornographic materials in Ohio at that time. Having porn was illegal, so they charged that person with that. However, any evidence they found, they said they had to throw out and exclude it because they did not have a search warrant to initially go in the house. So why do you think some people disagree? Again, judicial integrity. The courts should not be parties to law breaking. So the police broke the law. The courts should not support that. And deterrence. This makes police follow the rules, the laws, so they're not illegally searching people and then charging them with it. Most cases don't go to trial. We know they're expensive and take time. A lot of them are plea bargains. So the negotiation between the prosecutor, defendant, and defendant's attorney, they maybe have a lesser crime, lesser sentence, and they agree that they are guilty. The benefits to that, and the government can avoid all that time, and expense of a trial, the defendant gets a lighter sentence. However, some people feel that the government should have to prove beyond a reasonable doubt no matter what. Does sometimes let some criminals off the hook, or sometimes people feel like they're forced to do that because they can't afford to go to court, and they just plea bargain. So that's a quick look at the proceedings before a trial.